In a panel discussion hosted by the National Constitution Center, 3 originalist scholars were invited to discuss originalism and its history. At the end of the video, the host, Jeffrey Rosen, president and CEO of the National Constitution Center, asked each participant to give their best defense of originalism. Each provided a different argument, and I intend on creating a short video discussing each of those arguments. Here, I'll be discussing the defense provided by Sherif Girgis of Notre Dame Law School. To briefly introduce the topic, originalism is the thesis that judges should interpret the Constitution of the United States by attempting to discover the original public meaning of its words and phrases. To determine if punishment is cruel and unusual, we have to ask what people living in 1790 would have thought of was cruel and unusual, and so forth. Girgis ultimately provided 2 arguments in defense of originalism. The first argument goes as follows. Quote, there are lots of different ways you can set up a system. You don't have to set up a system in which judges, the people who apply a law, follow the original public meaning or anything very specific like that. I think that we, in fact, have set up that kind of system, and the kind of choices that a community makes as a matter of law, whether at the very broad level of creating its structure of government or at the more retail level of regulating particular conduct with particular laws, should be followed unless it's grossly unjust or has proven unreasonable and needs to be abandoned. The common good of the community is best served by that. Unquote. This may be understood as a burden of proof argument. It's the same type of argument used in a criminal trial. The accused is to be presumed innocent, and it's up to the prosecutor to prove, beyond a reasonable doubt, that the accused is guilty. Girgis is arguing, in effect, that originalism is the existing system, and whatever the existing system happens to be, it should be presumed legitimate unless a critic can provide proof beyond a reasonable doubt that it is, using Girgis's words, grossly unjust or has proven unreasonable and needs to be abandoned. So my first objection. The thesis that originalism is the default position is false. Girgis should be well aware of the fact that this premise is highly disputed. I dispute it. I take claims like reasonable and prudent in due process and unreasonable searches and seizures and cruel and unusual punishment to be taken like phrases be nice, play fair, show some respect, or do the right thing. They're not commands to do what the speaker judges to be nice, fair, showing of respect, or the right thing. They're commands to do what is, in fact, nice, fair, showing of respect, or the right thing. Second, Girgis provides us with a false dichotomy, that the only option, and it's only legitimate if originalism can be shown to be grossly unjust or unreasonable, is complete abandonment. There is a middle option that says that when a system is shown to be unjust and unreasonable, the least drastic correction is made to the system to make it more just and more reasonable. When driving a car, it's unreasonable to lock the steering wheel and to go straight ahead until you encounter a barrier that you can't cross. Then stop the car and change to a different vehicle so that you can continue on. One option is to put a steering mechanism in the vehicle that allows you to navigate around obstacles and sometimes change direction as needed. Here, I would expect Girgis to suggest using the amendment process to change the direction if a change is needed. But one of the things that needs to be fixed is this steering mechanism. It requires the full force of 3/4 of the occupants of the vehicle and no organized opposition to change the direction of the vehicle. On all significant matters, it is functionally identical to no steering mechanism at all. So instead of this false dichotomy of absolutist originalism or total abandonment, another option is that when injustice and unreasonableness is found, that a reasonable way for making adjustments be adopted to make the system more just and reasonable, and not forcing us to choose between extreme options of do nothing or abandon everything. Combining these 2 objections, I would argue that one of the reasons that the Founding Fathers used some vague terms in writing the Constitution was to create just such a steering mechanism. We can make smaller adjustments by interpreting these vague phrases, such as due process and unreasonable searches and seizures, in accordance with a continually improving understanding of these natural rights and duties. So now I want to turn my attention to Girgis's second argument. Now, the full expression of that argument is quite long, so let me see if I can boil it down some. Here then is a somewhat abbreviated version of the argument. Quote, I think that our reasons for adopting a written constitution are also reasons for applying the original understanding of it. The main reason to adopt a written constitution is that we face a bunch of crucial choices that we have to make as a community and that we are likely to disagree about if we just make them from moment to moment in some kind of free-form way. So it is precisely our expectation of future disagreement about what is morally or politically justified that leads us to tie our hands by a text adopted in the past. End quote. If anybody has ever been in a club or involved in a group project, they likely have experience with how all sorts of squabbling can prevent the group from getting anything done. To prevent this, a group might well say, here's a set of rules. Let's just abide by these rules unless somebody can come up with a serious objection or reason to change them, in which case we will then follow the change procedure outlined with the rules. Here, once again, Girgis seems to have provided us with a false dichotomy. The alternative to originalism is not, quote, we just make them from moment to moment in some kind of free-form way, unquote. In the analogy to the club or group project mentioned above, the options are not blind obedience to a set of rules or no rules at all. The rules do not have to be of a type that dictates every move and allows no exceptions. The rules can allow some discretion by, for example, allowing individuals to make reasonable expenditures considering the scope of the project, or to find a suitable location, or to assign a task to a qualified employee. In the same way that a project manager can use discretion in determining whether an employee is qualified to carry out a task, a judge can use discretion to determine if a process is what is due to an individual under the circumstances, or whether a search is reasonable or unreasonable. And note, a qualified employee isn't what the person who wrote the rule would have judged to be a qualified employee. The rule could have been written by somebody who has no idea what the qualifications are. Nor is it what the person making the assignment judges in some kind of free-form way to be a qualified employee. A qualified employee is that employee that has those skills and abilities that would allow them to carry out the task assigned competently. Here we run into the main point of Girgis' second argument. We're likely to disagree about what processes are due, about the extent of a right of the people to be secure in their persons, or their right peacefully to assemble. This disagreement is likely to lead to conflict. To avoid this conflict, we seek to tie our hands to what people who have been dead for 200 years believed at the time about these things. Unfortunately, this assumes that people living 250 years ago didn't have some of the same disagreements. Furthermore, we must expect that academics living today are going to have disagreements about what people living 250 years ago believed about these things. And I think I can guarantee that there will be disagreements over both whether we should tie our hands in this way or the specifics of how we are to be bound. So the idea that originalism is going to prevent disagreement seems a bit optimistic. The third problem that I see with Girgis' second argument is that the form of the argument is the same form typically used in defense of authoritarian dictatorships over democracy. That argument states that democracies contain too much disagreement and dispute. They can't get anything done. It's better to give the decision-making power to a single individual who can then force everybody else to go along without wasting effort on debate and discussion. If you all just did what you were told without all this bickering, we might be able to get something done. This is a legitimate concern in some circumstances. Militaries and corporations that depend on democratic approval tend to do fairly poorly. A ship often needs a captain. But if an autocratic captain is what is needed to avoid the pitfalls of disputes and disagreements, then I would argue that a living despot is better than a despot who died 200 years ago, leaving behind a set of instructions. At least with a living despot, we have an opportunity to convince him to change his mind when the rules aren't working. However, I would argue that we shouldn't be too quick to embrace the authoritarian leader who can't be questioned to resolve our disputes. There are advantages to a society in which people have disputes, where they debate and argue about the merits of different proposals, and where the best of those ideas can come to be used in our understanding and application of concepts such as due process. Girgis is correct. We can expect disagreement on the scope of a freedom of the press, or a right to keep and bear arms, or a right to a speedy and public trial, or whether a punishment is cruel and unusual. It is right and good that we debate these things and come up with improved understandings, and that we can have some way of incorporating these improved understandings into the law. But originalism tells us that we can study rights to freedom of speech, due process, reasonable searches and seizures all we want. It doesn't matter. It doesn't matter because our improved understandings will never influence the law. Judges are always and only to look at the opinions of those who have been dead for over 200 years to answer these questions. A modern scholar shouldn't even waste their time in investigating these concepts unless they get some type of personal enjoyment out of it. Originalism prohibits judges from giving their ideas any thought. So in summary, Sherif Girgis gave us two arguments in favor of originalism. The first was an argument that originalism is a default and that it ought to be assumed legitimate unless evidence shows that it is so unjust and unreasonable that it must be abandoned. I objected first on the grounds that originalism is not the default. The use of vague terms like due process in the Constitution are instructions for us to use our discretion. And I objected on grounds that Girgis's argument presents a false dichotomy between his form of originalism and complete abandonment. But in fact, other options are available. The second argument says that we should adopt originalism in order to avoid disputes. The problem here is that adopting originalism doesn't avoid disputes. There's as much to dispute about what people living 250 years ago believed counted as due process as there is over what counts as due process. Furthermore, the argument substantially follows the form: we should appoint a dictator whose dictates can't be questioned so that we can avoid fighting amongst our various factions. And third, Girgis's argument effectively states, for all practical purposes, don't worry about what counts as due process or a right to freedom of speech. Those decisions have already been made for you long ago, and whatever positions you come up with ultimately don't matter. Only people who've been dead for over 200 years have a say in the matter. Girgis's arguments don't convince me to accept originalism.